welcome to Legally Speaking with me, Tarun Nangia. Today is a very, very interesting show. Justice Suryakant has put forth an idea to have mediation in regional languages. Also, he explained the fact that India's mediation framework is also dependent on its reach, where it crosses linguistic barriers or regional line, because Romanized maxims wouldn't, the most of India wouldn't understand. And if you try to make them understand in disputes, they get even more confused. Justice Suryakant, of course, has a unique vision from the grassroots. We have seen more than ever whenever he speaks. So he said that if you could have mediation in regional languages, the pendency can go down a great deal. Recently at a function, he said it. Why this is important, how it should be done, and why his idea is important that he put forth. We'll discuss with an eminent panel. Let me welcome Justice Sanjay Kishan Kaul. As we all know, he is served as a Chief Justice of the Madras High Court, Chief Justice of the Punjab Haryana High Court, a judge of the Supreme Court of India, the second most senior judge after the Chief Justice of India. He was a part of the all-important collegium that makes appointments and transfers of judges. And now he is an eminent arbitrator. Good to see you, sir, and thank you for your time.
Thank you.
And we have with us Senior Advocate Arvind Verma, who practices at the Supreme Court of India and the Delhi High Court. Good to see you, Mr. Verma. I appreciate your time. We have with us Advocate Sri Venkatesh joining us, who works a lot in the APTEL, which is the Appellate Tribunal for Electricity, the Delhi High Court, and the Supreme Court. He joins us mid-vacation. Thank you for your time. And we are able to win you out from your vacation, but I think this will be worthwhile.
Thank you.
We have with us Advocate Aditya Ajgaonkar, who's back from his vacation because Bombay High Court opens soon. He will also sort of bring in the flavor from Maharashtra because, of course, a large state, the richest state in India, and what it means for rural Maharashtra. He'll also bring in that flavor. Thank you, Aditya, for joining us. At the outset, I would like to ask Justice Sanjay Kishan Kaul for his opening comment, and then we will go across to specific questions. Over to you, sir. What do you think of Justice Suryakant's suggestion?
So, Tarun, I think there is absolutely no issue on the fact that mediation must be carried on where the parties understand. See, unlike legal proceedings, which may be held in the English language and at high court level and also in district court happens in the local languages, the very concept of mediation, if you understand, and let me say this, I have been associated with setting up mediation center in Delhi, Chennai, in Punjab, Haryana, do mediation also actively. I'm a great proponent of it. The parties must understand what a mediator is saying. He's supposed to be a person who gets solutions out of them, bridges the gap, and therefore helps them in resolving the problem in a manner which may be often, I believe, better than a litigative approach, because parties can evolve their solutions which in legal proceedings cannot be evolved, as you are constrained by legal parameters. Here, you can find your own best way forward and have the best solutions. So, if the parties don't understand what is being said to them, I don't see how the progress would be made. I can give you examples of both Delhi and Punjab Haryana, where frequently the mediators used to be conversing in Hindi or Punjabi or something which the people understand, and I have witnessed those mediation proceedings. I even participated in them to give that comfort level. In Chennai also, which is very, very Tamil oriented, the mediators do converse in Tamil. So let me say only this is not a new thing, I would say. It's something which has been carrying on, but needs a greater focus, and certainly at district levels, mediation is important because if you resolve the smaller disputes, then the courts are left to decide the more serious legal disputes rather than the smaller disputes. It appears that this is what Justice Suryakant's focus is. As somebody who I headed the mediation committee in the Supreme Court also, we were encouraging always the mediation at the district level in the local language. So I fully support what he said.
Thank you for sharing your opening comment. We'll go to Senior Advocate Arvind Bharpa. Your opening comment on Justice Suryakant's suggestion.
In fact, Tarun, I totally endorse and second what Justice Kaul just now said, because this is the need of the hour, and it is something very, very it has come something. Mediation is the current need, because it fosters dialogue, it fosters understanding, enabling parties to resolve issues without getting into the recourse of litigation. Also, the fact that it is family disputes, commercial disputes, and community disputes. So all of them together need a mediation. Need mediation, especially family disputes are not restricted to. Earlier it was restricted, if I may say so, Justice Kaul's presence and my other colleagues' presence, and Tarun, you are there. Family disputes were earlier restricted to the upper middle class, the middle class, and the top bracket. Now, even the lower segment, especially in Bihar, in Rajasthan, and Uttar Pradesh, the family disputes, especially the younger generation, they are also arising. And interestingly so, what Justice Suryakant said, that in regional language where the mediator is trained to enter into a dialogue, their counsels are trained, mediators are trained in the local dialogue, in the local vernacular, to interact with them, make them understand that going to court is going to reach a point of no return. So this is what I feel, Justice Suryakant, and very interestingly, I just feel that he, in a speech or an article, he very candidly said that he was not for mediation earlier, as when he was a member of the bar or a practicing advocate. In fact, he said that he would prefer an adversarial litigation. So now, after becoming a judge, seeing the pain of the parties before him, cases after cases relating to family disputes, commercial disputes, brothers fighting. So it is the need of the hour, where I feel that mediation. In fact, interestingly, there was a matter where the family dispute between a very, very I won't name, a very, very upper middle class a commercial pilot and cabin crew wife. So it was before Justice Kaul only, in court, sitting in court number 2. And it was amicably resolved. So I would feel that this is the need of the hour, and especially his stress on that it is to be in the local languages. So, and also the study of it should be a 1-point curriculum rather than an extra subject. So that is what I feel, that is.
Thank you, Mr. Verma, for your Senior Advocate Verma, for the opening comment on this. I'll go to Senior Advocate Sri Venkatesh for his comment on what Justice Suryakant said and how it will be beneficial overall.
I completely endorse what has been said by Justice Kaul and Mr. Verma before me. And I think Justice Suryakant was perhaps addressing the issue from 3 perspectives. One, of being accessibility to quick adjudication of disputes. Second, mediation vernacular also perhaps adds to cultural relevance, which is otherwise found missing when one looks at typically high court and higher court proceedings. And lastly, the aim of instituting mediation at the grassroots level is also going to somewhat reduce the judicial burden, which the courts are right now grappling with, at least at the district, at every level, in fact. So therefore, this is where I think all the 3 objectives, if mediation is implemented in a structured manner at the grassroots level, even at the high court level, could be achieved. Only challenge is that, as Justice Kaul said, the provision for mediation has been there since time immemorial. There have been a few amendments in the Civil Procedure Code, Commercial Courts Act, and finally the Mediation Act, which came in 2 years ago. Therefore, the Parliament also feels that court's burden can be reduced if mediation is resorted to. The only thing that I think all of us are also agreeing, the undertone being, is that the awareness of mediation and how a mediation process can effectively lead to solution, this needs to be increased at a grassroots level and even at the high court level. Because more often than not, because when we are representing clients, we often see that they don't see the satisfaction in mediation. They rather litigate the matter right up to Supreme Court if need be, as opposed to going into mediation, without realizing that litigation, a long drawn litigation, is counterintuitive, counterproductive for themselves, as opposed to entering into a mediation and probably doing a bit of a give and take. So I think the Justice Suryakant is absolutely right that this has, if this implemented in the right earnest, can not only help the litigators but also reduce the burden on judiciary, which is as every year goes by, it only goes up. Lastly, I think in addition to the mediation at the grassroots level, I would wonder that why can't mediation be adopted in commercial disputes before specialized tribunals? See, so many times we have these long-drawn disputes in NCLAT, NCLT, Appellate Tribunal, all of them. And effectively, what parties are looking at is a forum to redress their grievance and arrive at a mutual settlement, because everybody knows their strengths and weaknesses of their case. It is only because you're fighting a case, so therefore you're fighting whole hog and not letting go of even what is not supposed to be given to you. So I think if mediation as a subject is implemented across the board, not just at family court or dispute, or at the lower court or grassroots court level, or even at the high court level, even in commercial courts or tribunals, perhaps the overall pendency would see a large reduction. But only thing remaining is that one has to increase the awareness of mediation in the country and what it can actually achieve.
Thank you for that opening comment. I'll go to Advocate Aditya Ajgaonkar for his opening comment on Justice Suryakant.
It's very interesting. Justice Suryakant has also said one more thing, that it's perhaps time we stop looking at mediation as a forum of alternate dispute resolution. Remove the word alternate from it. And I think that is a very interesting perspective because, whenever you call it alternate dispute resolution, I believe we sort of tend to give it a second-class status within the greater framework of dispute resolution. Now, the Commercial Courts Act already provides for mediation. But so many times we see, ad interim release being requested just to avoid that mediation, because people believe that it is a waste of time and nothing, will really get resolved. So I think change in mindset is required for everyone, whether you're a litigating lawyer or member of general public, to believe that mediation can be effective, and I think a great way to do this is to actually have mediators at local level. Another thing is, of course, when we tend to look at mediation, when we tend to look at, all these things coming together, we look at it from a very city-centric view. A lot of us are sitting in Mumbai, Delhi, etc. But when you're talking about it at a village level, when you're talking about it something at a district level, I think people's mindsets are very different. Even the lawyers' mindsets are very different. Issues are very localized very often. Everyone knows each other in a smaller town. And I think that would, in fact, mediation could be more effective at a local level, because, if you look at a village or district, the mediator will probably also know both the parties, so there is a sort of personal touch to it. There is a sort of history or background to it. And I think that could make mediation extremely effective at grassroots levels. Of course, the language barrier is something, because we tend to look at mediation again from an English point of view. But I think local languages, local mediators, well trained at the district level, and looking at it as a primary way of avoiding litigation, of being able to push it forward as a way of avoiding litigation, I think that could be a game changer by making it more accessible at the grassroots level.
Thank you for that opening comment, Aditya. I'll now welcome Advocate Vivek Jain on the show. He just joined us. Vivek, as we all know, practices at the Delhi High Court and the Supreme Court a lot of the financial crime side. He also serves as the Additional Advocate General for the state of Punjab. Good to see you, Vivek. Thank you for joining in. Your opening comment on Justice Suryakant.
Thank you, Tarun, for inviting me. In fact, I wholeheartedly agree with all the comments which were made by all learned English panelists. Being from Rajasthan, I can actually tell you that having mediation in a local language actually opens a lot of doors. And these doors are getting opened for the litigants. Imagine a situation somewhere in the village, in some district court, somebody is fighting a litigation. Now, there is only one person who is speaking to him in a local language, which is his own lawyer. Now, imagine if there is one person in that court which has some sanctity because obviously it is a court sanctioned mediator, speaking to him in his own language and trying to mediate him. So I think when somebody apart from your own lawyer, who has obviously grounds to tell you that you have a good case or a bad case, he can actually come and tell you that, see, it can be mediated. You don't have to fight for your life till your life ends. And in that scenario, it could have a lasting impact, according to me. Having seen trial courts, at least in Rajasthan, I've seen, like, I can only imagine when I was actually thinking about it, I can only imagine a mediator speaking in Marwari and trying to resolve dispute between two persons in Jodhpur, and that too in their local language. That is something very brilliant. It might not be as brilliant. It might not sound as brilliant to us right now because we practice in Delhi High Court and all. But for the people there in the small courts, it's a very brilliant thing because we should also agree that litigation is not cheap. So if you want to litigate, and most of all, these are family matters, land disputes, where you would have a lot of appeals provided. You have your original suit, then you would have your first appeal, second appeal, and then there is no limit to it. So there is no limit to which you can fight. So I think this actually puts everything in perspective for the litigant. When somebody in his local language, in his own district court, is telling him to please mediate and resolve the issue. Sometimes even the litigant doesn't even know that there is an option of mediating. There is, I think, that kind of awareness which Mr. Venkatesh had said and Naukar also said, that kind of communication, that kind of awareness is something which also has to happen. Though it's a very good idea, but I would also think that you need to have an infrastructure for that. I think you have to develop it. I think this can be developed, but you need to have an infrastructure like in Supreme Court and High Court. You would see a specialized mediation rooms where you make people feel comfortable. You would have chair, you would have sofa, or you can have some drinking water or something. So you have to make people comfortable before mediating. So you would have to spend some time and some effort on the infrastructure. And as Mr. Venkatesh said, that you need to have awareness about it also. So that awareness program also you need to spend some time and you need to spend some info on it. That's basically my opening comment.
Thank you, because your Marwari point was interesting because I myself know so many very well-to-do Marwari businessmen who will not be very comfortable in English, but they're excellent at their work. And of course, the court system can be a bit jarring for them. And what you gave is a good example in that sense. When you speak of this community which is so successful at what they do, pan India. I'll go to Justice Sanjay Kishan Kaul. Justice Suryakant said mediation materials must be available in all Indian languages, like court judgments. The mediation process should be available in all possible languages all over India. Now, sir, drawing on your experience on serving as the Chief Justice of Madras and the Chief Justice of Punjab Haryana, where you're directly in touch with in states, for example, in Punjabi Khadi Boli and Haryanvi is spoken in Punjab Haryana High Court jurisdiction. In Chennai, of course, in Madras High Court, the Tamil is spoken. Could you share with us what will be the impact if this is implemented in a well-meaning manner?
So, Tarun, let's understand first. I agree with what one of the panelists said, that it's really not an alternative method. In my view, personally, it is a better method. It is a better method because people get solutions in terms of what they want, not what is handed down by the court. Let me give you a little incident which occurred, I think, which relates to this. One of my good friends and colleagues at the bench once told me that one of the litigants, unhappy litigants, was in the Delhi High Court standing outside near the Khokas, and there are cold drinks and other things supplied. He asked for lychee milk. That fellow mistakenly gave him a cold coffee. So he asked him कि मैंने क्या मांगा था. तो ये said कि अपने इलायची मिल्क मांगा था, उसने दिया क्या? He looked at it. This is a cold coffee, दे दिया. He turns to his friend and says, ये पिछले जन्म में जज होगा, इससे मांगो कुछ और, देता कुछ और है. So the legal system is really like that. You are handed out something whether you want it or not. So therefore, mediation is such a successful issue across the world. See, US finishes 97% cases through mediation and alternative dispute resolution process. We are still fighting 99% cases in court. And in India, the Mediation Act has a very interesting history. During the COVID times, Justice Rohinton Nariman, myself, Indu Malhotra were in the mediation committee. Justice Narasimha was a member of the committee as a lawyer. We roped in all the mediators to draft the Mediation Act, vetted it, and then send it to the government. Of course, there are modifications in it, some of them, but the base was at the behest of the judiciary, which felt the need of mediation as an instrument to resolve disputes. And let me say, Rohinton chaired it, so you can understand somebody who's a hardcore litigator and judge person who propagated this issue of mediation. Mediation, I still believe, is held in the local language. The challenge, according to me, is how do you train mediators? If you say that anybody can be a mediator, personally, I don't think that's how it works. There may be community mediators, there may be legal mediators, there may be many kind of mediators, but they must go through a process of training. It's not the same thing. We often say that, हमारे यहाँ तो इंडिया में तो always, the panchayat was there. No, panchayat is a diktat because the panch give a diktat. It's not a mediation in that sense. So mediator must have the ability of eliciting what ails each of the parties, and then in the caucus sessions and then in the joint sessions, using his knowledge to see what would be acceptable and suitable to both of them. That's why you begin a mediation training with an example of an orange and say, look, if you have to divide an orange, the law will divide it half and half if you have 50% share each. But if you're a mediator and you feel that one needs the juice and one needs the rind to make a marmalade, you'll do that. So you get what you want. Now, unless you're able to converse at the level at which the parties are, incidentally, in a mediation table, we are taught. I've been to mediation training at different levels myself, personally, sitting with the lawyers. You have to sit not as the head of the table. It's always a round or an oval table which is sat at. So nobody is at the head of the table. You are at the same level as the other. To be at the same level, you must be able to converse them with the local language. So the mediation sessions I have attended in Delhi or I have attended in Punjab, Haryana, to just watch them in the training processes, and some of the very successful mediators were people who may not have been, if I may use the expression, such successful lawyers, but as a mediation concept were very, very practical and could elicit responses and find out what is the party. This can always happen only in a language which the parties understand. If the parties don't understand, then the same problem which in a legal forum would arise would also arise in case of mediation. Tamil Nadu, even at the High Court level, everybody knows Tamil. So when parties come, they may be coming from all over the state. Then there are mediations in district levels. Similarly, in Punjab, Haryana. So the mediations are invariably held in the local language, if I may say so. So it's very much prevalent, but we must train enough mediators who are capable of then translating this into a local language mediation initiative to see to it that they understand what is mediation, how to use the tools of mediation, yet use it in the local language. Maybe the mediation training booklets which are there at the moment being in English, possibly for training also we can have translation. It's not difficult with the AIA and other factors available to translate those into the local language, so that in the training process itself there is a better understanding by the coming in mediator as to how to deal with it.
Thank you for so beautifully explaining this for the audience and all of us with anecdotes. I really appreciate that. Makes us understand this issue better. I'll go to Senior Advocate Arvind Verma on what Justice Suryakant said on the availability of these mediation cases in Hindi. And also, as Justice Sanjay Kishan Kaul pointed this out, that the whole, the mediators should be conversant in the language. They should be comfortable explaining it to the parties. Would you reflect on that? That is it more of a mindset change that would be required if we were to implement Justice Suryakant's idea pan-India?
Yes, yes. I totally I agree with Tarun, with what Justice Suryakant's idea of pan-India and what Justice Kaul just now mentioned of mediation trained specific trained mediators, language specific trained mediators. That is what's going to be the need of the hour, and that is going to be the self-solving problems. Now, it was Chennai Madras High Court, if Justice Kaul will correct me. It initiated from that Dr. Sriram Panchu, senior advocate, the mediation center from there. Then the Delhi High Court, where Justice Kaul was there. And then various other high courts adopted this module. In fact, there was a time when I remember appearing in the Supreme Court, matters, family disputes, matrimonial disputes, disputes between brothers were referred to the Supreme Court Mediation Center, and this is pre-COVID. In fact, I'm talking about 2014, 15, around that time. Then parties or even councils, we would say that no, let it be sent to not the Supreme Court Mediation Center, but the Delhi High Court Mediation Center, because they had trained mediators. Those mediators had been sent to United Kingdom for training, and they'd come out as absolutely trained mediators. The mediators didn't treat it as any other case or a brief which they had to argue. It was they were trained how to deal with parties. They were trained, they wouldn't swing this side or that side. So that was there. Now, language specific mediator trained, because then matters come to the Supreme at the highest level. Unfortunately, ultimately, what happens is that matrimonial disputes perhaps get settled at the High Court level, but at the family court level, they have been settled. But that's my personal experience, subject to correction, what Justice Kaul and my other colleagues say, that ultimately commercial disputes, even matrimonial disputes, are ultimately settled by the apex court. And
yes,
it is not that I would say that, yes, in a lighter vein, Justice Kaul was very kind to say that what is handed over, ultimately, it is an amicable situation. Very rarely now what has happened that the matters are carried in camera to the chambers. Everything is amicably decided in open court. I'm saying from personal experience, Mr. Venkatesh, Aditya, and Mr. Vivek Jain will all agree with me that it is all these matters, commercial dispute, they say go back to the mediation, an appointment of a mediator. Now, language specific, I would say that from the district court, a panel should be with the district judges consultation, a panel of lawyers from the Chief Justice of various high courts and also Supreme Court. There should be different mediators chosen and trained, maybe in Delhi or other places. So where language specific, vernacular specific, if that is what Justice Suryakant perhaps is driving at, and that will be the solution.
Very well said, because even in a state, India being such a vast country, states are very big, and one part of the state speaks a different language from the other part. So localized training may be essential. I'll go to Advocate Sri Venkatesh. Justice Kaul made an important point where he said 99% of cases in United States of America settled by mediation. In a country, where the cases are much lower than India, we have 6 crores at the district court level. Do you think there are immense possibilities given, that we are not at all equipped, given the kind of judges in the amount of judges that we have, very less in number? Do you think this is the only way out given the current situation? And what I also understand that Justice Suryakant said it because most of these litigants can't afford to come to High Court or Supreme Court. They don't have the money. Of course, there may be some, but not many.
So, Tarun, as Justice Kaul was referring to, the United States of America has a high percentage of resolution through mediation because the cost of litigation there is prohibitive. In India, even though it's expensive, it is still not prohibitive, because here you don't have the concept of paying damages the way you pay there for a vexatious proceeding. Therefore, perhaps that's why parties more often than not would like to take a chance by going to the next forum. But that's why, we have this habit of litigating till Supreme Court, because we feel that's and even after then there is review and curative and so on and so forth. So I think you're right. And Justice Suryakant's vision, according to me, is also correct to say that this large backlog can be to a large extent reduced if a focus-based mediation approach is adopted. But this requires all stakeholders to play, have to play together. For example, awareness, like I spoke about in the beginning. But even if you create awareness amongst litigants that mediation is a way forward for you to arrive at a solution where you will get something out of your dispute. The question is, are the institutions at the grassroots level equipped to handle large-scale mediations as of today or not? According to me, some amount of strengthening is required to be done at that level, and which has to be done with both the government and the judiciary working hand in hand. We already have a high court level mediation center, which Mr. Verma and Justice Kaul were referring to, which is very robust, which works very beautifully well in inter-family partition disputes or marital disputes. But similar systems are perhaps not available with that efficiency at the lower court level. So one way could be that pre-institution of a proceeding, one could leverage the existing panchayat system. I understand that panchayat system is not a mediation system in its own sense, but the system is quite robust and it's all over the country. So if we can appoint mediators from the panchayat system to resolve disputes even pre-institution of suit, then perhaps that could be one level where a lot of disputes can be weeded out. Then when you come to the district judiciary, if the district judiciary has standardized training for mediations, a robust, ultimately we have lawyers graduating every year in lakhs and numbers. If we prepare mediation as a viable solution, as a job perspective for such lawyers, and if there's standardized training for them to understand what is expected from them in being non-partisan and in being objective while carrying out such mediation at the grassroots level, then perhaps post-institution of suit also a large number of cases can be referred to mediations if the system exists. Now, for example, before the Honorable Supreme Court, so many times when we are doing a family matter, we know that we have lost in the courts below. But we know that if we approach the Honorable Supreme Court in an SLP and request for a mediation under the aegis of the Honorable Supreme Court, a viable solution can be arrived at. So therefore, at some level, parties are aware that mediation can get you out of trouble when you are, when such disputes are going on. But so therefore, to answer your question, I think the awareness is one aspect, but creation of a robust system where there is enough judicial training for these mediators and perhaps a cadre where young lawyers look at mediation as a possible source of long-term revenue or income. Then if that system is created pre-institution and post-institution at the low grassroots level, then perhaps potentially in the next few years to come, maybe in a decade or so, a large number of cases which are clogging our system can be resolved. And ultimately, mediation is nothing. It's a very famous saying that mediation is the result where both parties are a little unhappy, and that's the best result, because ultimately you do a bit of a give and take and you get out of it. So I think that could be one way. That could be a way of implementing it. But this would require, I think, all the three organs of our country working together to implement it at a large scale level. It may not just happen by the judiciary wanting it to be done in this fashion.
Point very well taken, Venkatesh. I'll go to Advocate Aditya Ajgaonkar. Aditya, Justice Suryakant said mediation materials must be available in all Indian languages, and of course the process. Take an example of Maharashtra. You come from the city of Mumbai. And of course, business happens in all districts of Maharashtra. Not everyone is conversant with English. Of course, urban centers, people are aware, but for most of Maharashtra, no. Do you think this is an implementable idea in various districts of Maharashtra?
Tarun, I'm going to say something slightly incendiary out here. Mediation is in our blood. If you think of the institution of arranged marriage, okay, usually the traditional matchmakers have been those who have capability of knowing both the families, and the comfort is in the fact that if tomorrow there is any sort of difficulty, that person will step in and make sure everything moves simply. It is just unfortunate that when it comes to commercial disputes, we have to talk about so much, while everyone is more than happy to try and implement that in family life. Not really that incendiary, this thing, but the comparison is very stark, because if you actually look at it at the district level, having village elders, having people around, because I am not even looking necessarily at the district level. Let's look at a village level, right? Because we have civil judges sitting even at a village level, in the smaller towns, etc. The characteristic of the people, the culture changes every little few hundred, 200 kilometers in our country or even in our state. The nature, the cultures are very, very different. What is fine for one, what is not. Dialects change. So I am very vocal for local when it comes to mediation. So, not only am I wholeheartedly endorsing and, really behind what Justice Suryakant said, that there should be local languages. But I say, let's go one step forward. Let us say, not only should the mediation materials be made available in local languages, but let the high courts also come up with their, keeping the cultural ethos of the people in their mind. Let them, in consultation with the government, come up with localized rules also for mediation, which may be different, because cultures of people staying in different states in our country is very, very different. And we have to embrace that unity and diversity also. So I do not think like in a city like Mumbai, in a city like Delhi, for commercial cases, etc., we can have certain rules for mediation. But if you're looking at a smaller village, if you're looking at a smaller town, a lot of the actual dispute is family related. You have ancestral lands that are coming down over the years. You have neighbors saying, you're basically kith and kin staying in the same property but fighting over it 3 generations down. Testamentary issues come in, and these are things that can be very easily resolved by mediation, by a local person out there who will well conversed with, who will well versed with the local culture, with the local dialect, with how people's mind think everywhere, and what it is that they can come up with. I think this also goes to what Venkatesh was saying earlier, that everything has to be very, very clearly, brought out at a local level. We cannot just say that, with all due respect, I do not think some mediation rules that come out of Delhi or that come out of Mumbai can be made, just copy pasted and used at a village level, because again, as it was brought out, we have a big appellate system that comes out. Okay. And as Venkatesh said, everything has the potential to turn up in the Supreme Court after 30, 40 years in a civil suit, right? Because one appeal, second appeal, as long as the parties have the resources to keep fighting, access to justice is a concept that we embrace. So it can reach the Supreme Court. And I also think that a lot of matters are settled at the Supreme Court level by mediation, because by then people are also very tired of fighting. If some consultation can happen at the grassroots level, where they are told that, listen, 30 years are going to go, and the solution is very simple, you can both go home happy, and this can be drawn up. I think, by a local person, that would make a huge difference. Also, mediation would be more effective than, local interference running, because uh, people need a stamp of authority also. I have not, this is my limited experience, that a stamp of authority on a settlement, or even an understanding, makes a huge difference. A lot of concerns that actually happen amongst litigants is, what if the other person reneges on what they have promised or committed during the mediation. I think that if proper rules at district level, at a at village level, etc., are come up with by, say, the high courts at a local level, they can be a game changer when it comes to mediation.
Thank you for your comment and explaining this for a bit. I'll go to Advocate Vivek Jain. We have a candid question. I mean, a low density state like Rajasthan, lot of ancestral property, not much manufacturing, but big on tourism, lot of land disputes. Do you think makes it a fit case for this kind of project to be implemented, mediated settlements?
Well, you're absolutely right, Tarun. And I'll actually give you an example. Since a lot of clients come to me from Rajasthan, There was a case I was doing where a person came and met me because of some local person. He told me that you go meet a Supreme Court lawyer. I don't know why this thing is there that you go and meet Supreme Court lawyer in Delhi. So he came to me and he explained me, sir, this suit is going on and I'm fighting it. And I'm just going to win it. And that will be all. I'll get my land. Now, there was nobody. So I realized a very peculiar situation that in his village or in the district court, there was nobody for him to actually explain him that, see, this suit would be contested in appeal. And then from appeal, it will go to second appeal, and perhaps it can go to Supreme Court also. When I actually put the things in perspective to him, that, see, this is not the end. There are appeals which are provided. The matter can come to Supreme Court. This was a valuable land in some village. He actually realized it. I don't know what happened. They might have mediated and would have settled. But one thing which, when this Mr. Justice Suryakant had said that mediation in the local language, then this thing actually occurred to me that, see, if somebody could have met this person in the village in his own local language and could have made him understand the nitty-gritties of litigation, and that is why you have lawyers as a mediator, so that you can put things in perspective for the litigants. That, see, this is not the end of the road. There are appeals. You would be tired. There will be litigation, which would ensue in future. So I think it will be a game changer. According to me, it will be a game changer to have somebody in the local language telling somebody that, see, this is not the end. You need to settle and go home and you compromise. Both the parties compromise. One thing which I actually was thinking is that, see, it's very difficult to actually enforce mediation like this. And so, therefore, there has to be some force of law or maybe some rule to say that you should do some mandatory mediation in at least family matters, land dispute, or specific performance dispute, because these are the disputes which come from the local courts. Because, it's easy to say that there is an option of mediation available, you go for mediation. But why can't we just have a rule to say that you do a mandatory mediation and maybe have a time limit to that? So you would also have some kind of a force
Yes.
behind that mediation to be done. And I think that is something which can also go a little, yeah. So that would also create awareness about mediation, because once something is forced on you by the law or by the rule, and once you do it, you would generally get to know about it. You get awareness about it. And this actually also, I think every lawyer would have actually, I think Venkatesh, Aditya, all have experienced that you would, some local matter you would be doing, and you would see that both the local lawyers are taking dates after dates, and the matter in the suit is going for years together, 10, 15 years, the matter is going on one date, one lawyer is taking date, on the other date, the defendant is taking date. So I think if you have a mediator and somebody in your local language who is a neutral person, not your lawyer or the other side lawyer, it might influence the people to settle the dispute.
Point very well taken.
Last, yeah.
Yeah, tell me.
Last thing which I had in my mind was, and I think Mr. Venkatesh also said that you have to make mediation lucrative. You have to make it lucrative. Something needs to be paid to the mediator, because at the local level, at the village level, if you expect somebody to do mediation and not go for the cases and not fend for his livelihood,
Vivek, I would
then
have to stop you because that's my next show topic. So that's the
okay.
topic for my next show.
Okay. So I would just end by a quote which I just stumbled upon, that an ounce of mediation is worth a pound of arbitration and a ton of litigation.
Okay, point very well taken. Justice Kaul also does quite a bit of mediation in addition to arbitration, which he does full time. I want to take the final comment on this show today from you, sir. But one thing is that the total number of cases are 6 crores which are pending across district courts and high court. Land and property disputes are the highest number of disputes across the judicial spectrum. Judicial vacancy is more than 33%, and in 21% in district courts also the judicial vacancy is excess of 21%. while you were there, I think the Supreme Court pendency was about 60,000 cases. I think now it's around touching 85,000. So I think the system is creaking. Do you think only mediation can save us given this plight?
So please, Tarun, just understand one thing. When we are talking about base level mediation, uh, it saves the appeals, it saves the further tiers of scrutiny. But still, mediation can be successful at every stage. My own experience shows sometimes it doesn't settle at one stage, a little bit of litigation fatigue settles at second stage or third stage. So it must go through parallelly in every area, but base level will help us save a lot of things going ahead. See, something was being mentioned about mandatory mediation. Well, let me tell you, in the act originally which we had prepared, there was a requirement of mandatory mediation, but the discussions with the government came to such a pass that the government felt that it's a catch-22 situation. Unless there are enough mediators, they wouldn't want to impose compulsory mediation. So what I had advised that time was that till you don't have compulsory mediation, mediators may not come up at that level. Let me also put another thing that you said it's another program that at different levels it has to be worth the while of the lawyers. In America, people switched over from litigators to mediators. So it may not necessarily happen at every stage, but that's equally important. And see, when we say the solutions possible, it's not only family, it is commercial in every field. Land disputes, certainly a lot of egos involved, so mediation can help. I'll again give you one example, which Sadhna, God bless her soul, was one of the active mediators, Sadhna Ramchandran. And there was a family dispute where husband and wife are already divorced. And there was an issue about the custody of the child. She felt in the mediation proceedings that the parties are not so far apart, but maybe the parents played a greater role on it. She encouraged them to live in the same flat separately. Net result was not only was there a settlement on the issue of the custody, the parties actually got remarried. Now, how in a legal system, you tell me, in a legal strict sense, can it never be achieved? So one is the better possibilities of solution. Number two is that you save cost. Number three is you unburden the system. But there has to be some systematic approach. And I'm afraid I never found the government role, despite this, very encouraging in all this, because government is very large litigant in the system. They are still very hesitant to mediate. That signal must go to the government also, that land, revenue, and other disputes often arise not only between parties, but between government and the local level, and they play a role. Unless they are willing to adopt a constructive approach to mediation at different levels, the success rate will not be so much.
In fact, you said it very well, because my data grid tells me more than 50% cases involve the government as a party. So more than 3 crore cases are the government.
Nobody checks up how much is the success rate which they achieve in litigation to be able to determine whether they should be litigating or not. That's a good test. Maybe people don't want to take responsibility. You can create, I believe, smaller committees which can examine which cases can be settled with private parties. The government must take the lead in trying to see people don't have to litigate. Our country has such a huge service litigation. Supreme Court, one of the largest areas of litigation is service disputes, whether we try with the government or public sector enterprises. Means dissatisfied employees, not good for the system. Number two, you are spending time on litigating with your own employees. This is just an example of why the government must take a role.
In fact, I don't know how many times Justice Kaul has requested and said that judicial appointments must be done. I think one good thing is in your time we saw a large number of appointments and you kept on pushing for them even later, which doesn't happen as much. But I think we should thank you for that, what you did, given how slow. I mean, let's hope appointments process speeds up. Recently, I had an opportunity to listen to a judge from Madhya Pradesh, and he said, Tarun, come to Madhya Pradesh. The cause list shows 330 cases before the judge every day. Now, how on earth can it?
Tarun, just go down to Delhi High Court. 100 cases. What will they do? So you have enough appointments, they don't even have time to think which case should be mediated, which should be sent to mediation. This is something is a little touchy issue with me. I really feel unless we are able to appoint judges to the strength they have, forget increase the strength of judges.
Yeah.
No system can work in the
Yes.
legal system.
Yes, very well said. I would, and Vivek, of course, I cut you short. Your topic is my next show topic is on fees of mediators. That I think you'll speak a lot more on that one. But I appreciate all of you could join. Thank you, Justice Sanjay Kishan Kaul. We really appreciate your time always. And one thing we appreciate that you're frank with your views. You're not guarded with what you want to say, and that adds to the discourse in the collegium and the courts that you speak up so frankly. Advocate Sri Venkatesh, we pulled you out from your holiday. Thank you for joining us. Senior Advocate Arvind Verma, thank you for bringing your candid views also from the grassroots. Advocate Vivek Jain, thank you so much. Advocate Aditya Ajonkar, who joined us from Mumbai and brought in the view from Maharashtra. Appreciate your joining us. Indeed, a very robust discussion today on what Justice Suryakant said on mediation. We'll definitely follow this up after 3 to 4 months to see what happened of this and add to this discourse. Appreciate your joining us. Thank you so very much. Thank you.
Thank you.
Thank you. Thank you. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.